Welcome to Justice Serve TV. Michel Bryant here. Kenney Baden, of course, on assignment, and we're going to get into that. We're also going to see how Aidan Kearney has thrown down the gauntlet in the latest action against him, and that weird case out of Vegas, the former porn star and the decapitated baby daddy, all coming up.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, may I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All right. Once again, welcome. Michel Bryant here. Where is Kenney Baden? We thought maybe she'd come on tonight, maybe not, but this whole mess in Atlantic City has it's far from resolved. And so we're going to talk a little bit about what's going on there. And then we're going to talk a little bit about this case in Las Vegas. Technically, I think it's in Henderson, which is just about 16 miles southeast of the city, where a former porn star is accused of chopping off the head of her the baby daddy of her two little girls. And oh, by the way, she is now married to her stepson. But I mean, yeah, it's Vegas. So anyway. Okay, a couple of things. One is really just a promo. Let me just do the promo. I did an interesting interview today with Haley Robson. She is one of the very outspoken Jeffrey Epstein survivors, talking about, well, this was not just a quick beat on your basic mainstream media. We did a full hour, and we talked about everything. And so that's going to premiere tomorrow night at 6 o'clock, give you a chance to tune in and make comments as it unfolds. Everything from the death of Jeffrey Epstein, her involvement with him, her involvement or lack thereof with Ghislaine Maxwell, what happened to Ghislaine Maxwell, what might happen to her, the issue with whether to release the Epstein files. We'll talk about what are the Epstein files. It's like Kleenex. It's a generic name. Nobody knows what the hell it means. So we talk about that and a few other items. An amazing person, and I hope you will tune in for that, and we'll have chunks of it probably rebroadcast over the weekend in case you can't devote to the full hour. Tonight, though, yet another amazing guest. John Mateus was involved with Mark Randazza as we fought for our First Amendment rights in the Karen Reed case. Remember that the buffer zone was in place to the point that I was stopped by the cops. Because why? Because I walked across the sidewalk right there in front of the courthouse 5 times. What is wrong with me? It's insane. And so they said, you don't get to do that anymore. And that was kind of the last straw. They also ripped I guess it was a sticker supporting John O'Keefe, the deceased Boston police officer, ripped it off his jacket. And I happened to catch that on video. So those are things that aren't really good and a violation of First Amendment rights, not just because of journalism, but a human being. So if you enjoyed the massive crowd that appeared outside the courthouse there in Dedham on the day that Karen Reed was acquitted, I'll take just a smidge of credit, give the rest to Mark Randazza and to this guy, John Mateus. John, how are you, buddy?
Good. How you doing, Mr. Bryant? Michael?
Don't call me Mr. Bryant. What is wrong with you?
I'm a very formal man.
I do respect that, but it just feels weird coming at me. Let me ask this, since we talk about Karen Reed, we're going to get into Aidan Kearney's situation because a new order under which he is supposedly being prevented from maybe First Amendmenting. We're going to get to that. But Karen Reed, there's still some things dangling out there. You said there was an appellate brief, an amicus brief just filed. What's going on?
Yeah, even though the case is over, we are, well, I shouldn't say we, but many of the people who were affected by the buffer zone order are still appealing that. And you might say, well, the buffer zone's been removed, so what's the problem? Well, in American law, we have a tradition of a wrong. Even if it's removed by the government, you still want to appeal it if it's constitutional enough, because we want to say in the future, don't do this in case, or maybe in the future do this. And so the appellants from that buffer zone order are still appealing, and I'm representing some of the same amici defendants, writing a brief saying, yeah, that buffer zone was wrong. Here are the constitutional reasons why. even the district court, when it re-ruled on it, we don't believe that solved the issues, and we believe that the First Circuit, the appellate court below the Supreme Court, should speak on that.
Yeah, and it was kind of a kissing your sister decision when it came down, because we really didn't feel they went far enough. But at the moment, it was a victory, and certainly there was evidence that it paid off to some degree. But it was still, there were still guide rails that seemed to be anti-First Amendment. So you're fighting on that as well I guess, to set some sort of precedent going forward that it's a little cleaner than what we have at the moment.
Yeah, one of the problems was when the district court re-ruled on the buffer zone order, it said, on one hand, oh, everything's clear here, so therefore it's constitutional. But on the other hand, then it started to name specific phrases and instances that were okay and were not okay under the buffer zone order. It gave very lengthy footnotes. So clearly the district court itself wanted to clarify the buffer zone. And if it felt the need to clarify the buffer zone order, then the buffer zone order was vague and overbroad, and therefore should not have been upheld as constitutional. At least that is part of our argument. We're going to be filing our amicus brief early next week, and the opposing side, the government, still has to file theirs. So it's going to be a while before we hear a decision on that.
Yeah, it's I have just read, I'm going to do a little short on it over the weekend about this Maine decision regarding a buffer zone. I don't know if you saw it, but there was a bunch of marijuana distributors. The underlying crime is almost irrelevant, but the prosecution wanted a buffer zone, didn't call it that, but they were specifically trying to avoid the defendants packing the courthouse with supporters. Sounded very familiar. And also not to use their social media to in any way try to influence potential jury pool members, right?
Oh my gosh, I can't believe that they came out.
I'll have to send you this. I'll send you this order because it's encouraging. It's 2.5 pages of get over yourself, prosecutor. I hope more people pack the courtrooms. That's what the judge said. I hope we see more people taking an interest in packing the courtroom.
That's right.
If it happens to be because they support one side or the other, so be it.
That is their American right. That is their right under our judicial system. Look, if a large number of people vote very passionately on one side of an issue in a court case, get to court and be heard. That is the point of having open courts. I mean, there's constitutional rulings that state you can't clear people out of the courtroom during jury selection. So the very fact that, and jury selection might be arguably the most sensitive time but they're supposed to be there. And if they want to protest, or I should say demonstrate, or at least silently give their opinions, they should be allowed to, in my opinion. Just free for all.
Yep. So I'll send that. You'll appreciate how the court handled that whole mess, even including the social media stuff. It qualified saying you can't, incite, the things you might not be able to incite either in person or online, but not just talk about it, not just encourage participation. Anyway.
Totally agree. Social media for that. I mean, look, New York State has now a gun law that says before they give you a gun license, they want to see all your social media. They want access to it, which is, in my opinion, flagrantly unconstitutional on the First and the Second Amendment. And how that goes down in the courts will be fun to watch, I believe. Yeah,
there is. I mean, definitely there's some, Wild West with some of this social media stuff, and it's going to have to be dealt with. But to me, if it's out there, they can see it, right? I mean, what would they need? I mean, they can do what they want with it. You can then decide whether or not that's appropriate. But it's not like they have the right to maybe dig into things you've deleted or posted years ago,
or under a pseudonymous name. Many of our founding fathers wrote things under false names precisely because they did not want prosecution or persecution in the manner that the courts and the legislatures apparently think they can now do. I mean, we've come full circle from Publius back in the 250 years ago to now even your 14-year-old out of context, perhaps off-color jokes can be used against you in a court of law to deny you your basic constitutional rights. It's absolutely awful, and I hope the next generation of constitutional lawyers are fighting for it.
Yeah. Well, speaking of awful and things that are unconstitutional, let me give you the backstory here. And I'm not as worried about the merits of this particular case because we don't know much about it, but the core First Amendment issues, that's your thing, and that's why I want you here. So, Aidan Kearney, who's been assailed by many folks who are not happy with him for whatever reason, he's not shy, and so he may say things that upset people. And there's been apparently, and this is new because it's been squashed by the court to the degree that it's not even supposed to be talked about by the defendant, Aidan Kearney. But an individual, and this was filed in Atlantic City, which is the county of Atlantic, an individual claims that he has said something about her, we know it's a her now, and or her family in a way that she didn't like. I don't know, hurt her feelings, something. She goes to court and asks for, as anybody can, basically a temporary restraining order. Please don't let this person bother me. Now, normally, it would be prohibition against physical contact or phone calls or anything that is a direct contact. I don't believe social media is a direct contact, but that's maybe someday it will be, John. I mean, who knows? But at this point, it needs to be more aggressive and more traditional in terms of contact. So that gets elevated, I'll use that word, to what we're going to look at, which is the newest provisions in that order. And there's been no hearing. That's another issue. This came about on November 5th. Okay. So a couple of days from now, that'll be 10 days. Tomorrow's Friday, the 14th. So it's not going to happen within 10 days, which is statutorily the theory. And why? Because it's temporary. And it's such an infringement on your rights that should be in front of the court as soon as possible. Well, it hasn't happened yet. And now this is the latest version of the other relief. Whoops, too much. And this was published by Aidan Kearney. As I say in the title to our show today, he's thrown down the gauntlet, because as we read this, it looks to me like he's saying, oh yeah, other relief. And again, this is part of the temporary restraining order. Other relief, defendant to immediately remove any and all social media posts referring to plaintiff and family members, specifically any reference to plaintiff family members, any personal information or court-related issues or documents to be removed immediately. Failure to do so is a violation of this order and an arrestable offense. Any further posts referencing plaintiff family, town, work, or anything else is a violation of this order and arrestable defense. And that's signed, the hearing officer, I think, sends it up to the PJ, which is Rodney Cunningham. Good work. Great work, dude. I see nothing wrong with this, John. It seems to be perfectly reasonable.
Oh, man, this is so awful. This is what they might call in the First Amendment law a prior restraint.
Yes.
A prior restraint is basically what it sounds like. It's where a court or legislature or a government body, before you even say something, says you can't say it. And there is a very famous case going back to 1931 called Neer versus Minnesota. And it was a Supreme Court case that basically struck down these kinds of things in a very famous decision. And one of the things was that this kind of idea that you can pass a law or a court can state you can't say anything in the future about this is, almost alien to American and English law, which is where we call it Anglo-American law. We get our law from England. It said that the fact that approximately 150 years of the country, there's an entirely absence of attempts to impose previous restraints upon publications, quote unquote, is significant of the deep-seated conviction that such restraints would violate a constitutional right. Basically, in Neer versus Minnesota, it was a similar case to this. The situation was they used a law that said no defamation or malicious publications to completely shut down a newspaper. They said, well, in the future, you're going to publish something very scurrilous, so we're just going to shut you down. The Supreme Court said you can't do that. You can sue them for things they have said, but you can't say, well, you're a bad person. You're not allowed to talk anymore. And they were actually right, because the publication was publishing a lot of things about, at the time, the intertwinedness of politicians and bootleggers, because they were all on the take from bootleggers in Minnesota. It was coming down from Canada and getting to American cities that way. So that's a classic prior restraint. The government can't tell you what you can and cannot say in the future. It can only punish you for things you've done in the past. And this last sentence, that was the first thing I noticed about this. Any further posts referencing the plaintiff or the plaintiff's family, the town, the work, or anything else involved. Look, You may not like him, folks, but Aidan Kearney is a journalist. Okay, he is protected by the First Amendment to say those kind of things. I don't know how the town or the work or anything.
I don't either.
Or the plaintiff's family. I will say, I'm not licensed in New Jersey, so I can't speak about what plaintiff's family is defined under the law there. But in most restraining order cases, it's only applicable against the plaintiff. The plaintiff gets the protection, but not the entire family. How is it? It's like your third cousin. You can't talk about him. And the second thing is, we don't know the context. If he's actually reporting valid news, and he's not, this isn't a personal matter. And again, there are kind of exceptions if it's like, two people who have an intimate relationship and, you're being nasty back and forth. Sometimes they can restrict that. We've seen gag orders in various cases, criminal cases. Even the president was gagged in his case. But this is just so ridiculous to shut down a person who is clearly a news maker and a news reporter from ever speaking about whatever it is they're speaking of. It's just, I hope he's got his First Amendment lawyers ready, and I hope they're ready. They're chopping at the bit. I hope.
You may know at least one of them, Kenney Baden.
Oh,
which is why she's on assignment, and also Darren Gelber, who he's a New Jersey lawyer as well, very very well respected. He used to come on Law and Crime when Linda and I were both there. He used to be a guest on there, so he's got the firepower. It doesn't make this any less ridiculous. It may make, and I'll give you my thoughts on this and tell me your experience with court dockets. My biggest concern is that this is at the TRO level. This is not like there's been a big evidentiary hearing where they've ferreted out what the issues might be and the seriousness of whatever the allegations might be and proven them true. Therefore, boom, here's what we're now going to do to remedy the situation. This is so out of control, so far ahead of any fact finding. You can just say whatever you want, and this judge or the office, and then rubber stamped by the PJ, will just say, okay, fine. Okay.
Look, and I'm sorry to say, I again, not licensed in New Jersey, but having a lot of experience working in restraining order cases and harassment order cases, which are very similar. You see, this is actually going to be a big constitutional area of law going forward, because there's nothing wrong with restraining orders and harassment orders to protect people who are in need of them. However, the problem becomes many of them, again, grant protections without a hearing, or tend to rubber stamp them, especially in certain demographic circumstances. And then there's the question of, like, some of them are massively overbroad. For example, here in Massachusetts, the restraining order and harassment order language, if you read it strictly enough, it would actually prevent the defendant's lawyer from actually talking to the plaintiff's lawyer, because it says any agents, and any attorney is your agent for the legal circumstances. Now, I don't know anyone who's ever been prosecuted under that, but the language is so overbroad that it prevents these sorts of things. And in this situation, this just seems like they're given out like candy in many circumstances. There needs to be a lot more restrictions upon them, in my opinion. Otherwise, we're going to get huge constitutional issues like this going forward. It just shouldn't be. And again, this was done in New Jersey. Kearney is clearly a I won't say the term, but he's a Massachusetts resident. I don't even know if you don't get notice of these until after they're passed. How is he supposed to get there? And thanks to VAWA, these kind of things are given full faith and credit. So Massachusetts must recognize this under VAWA law if this is a romantic situation, or this is a female doing it against him, which I believe you said it was.
It's very fuzzy, but we do know it's a female complainant or plaintiff, and it's obviously Aidan Kearney defendant. So your description there of Massachusetts doesn't surprise anybody that they would have a law that's written so broadly that it really shouldn't even be enforced, and perhaps maybe they haven't and won't ever enforce that, but that makes perfect sense in Massachusetts. One of the other things I thought was interesting is this was on calendar for yesterday. Okay, the reason these TROs, I'm not telling you anything. The reason these TROs are so short is because you're infringing on somebody's rights. Therefore, let's get it in front of the court as quickly as possible to find out if it's valid or not. If it's not, we'll get rid of it. If it is, we'll enforce it, maybe for a longer period temporarily, maybe for permanent. Who knows? A lot of these, domestic violence type cases, they make them permanent, and it's a violation for the party to break that restraining order, and that would be arrestable. But you got to get in front of the court. You can't just leave this temporarily dangling out there, because at what point does temporary become more than temporary and further infringe on the person's rights? So there's a hearing yesterday that last minute is pulled off calendar. So we're busy. We're just busy. We're just way too busy. Now, if I'm looking at, tell me your experience with the docket. I'm looking at a number of matters on the docket, and there's only so much time, so much court time. Wouldn't a TRO be pretty high up the list of things that you should be addressing?
It should be. And this is another problem with restraining order matters. For some reason, at least, again, not licensed there, but in Massachusetts, where I've handled a number of them, they can often be put at the back of a line. First, obviously, would be criminal arraignments. That would be the most important for people who are arrested. But, I mean, it definitely should be bumped up ahead of time, especially one that's about to expire, and especially one that so restricts First Amendment rights. I think the part of putting this to the back of many, to the back of the line in many of these circumstances, is the idea that they'll just by not handling it on a certain time, it gets extended, or we have to have it for another day, or we have to come back in 5 days because the court is very busy, and so now it's a 15-day TRO. And I have seen situations like that where it's been extended because one of the parties can't show up. And if the plaintiff can't show up on that TRO date, they will extend it in a restraining order matter, at least up here.
Which to me is also a flagrant abuse of the system.
Right. It's grossly unfair. I mean, if you really were the kind of person playing with this falsely, just keep making excuses, claim you're in the hospital, and then you get a free month before you have to actually. And then hopefully when you come back, the defendant is so busy working, which has happened in my cases, that they can't show up. Or their attorney. I've had cases where I will show up for defendant, but the defendant has to work that day. And I said, Your Honor, I'm here to contest this, and this person can take the day off. And they go, well, if he's not here, I'm just going to deny your motion to vacate. I'm just going to grant this for another year. And I go, Your Honor, my client just can't be here for, we don't need to, he doesn't have to be a fact witness. So I'm just going to argue the law. Nope. And we get shut down like that. And it's very, very disheartening. And restraining order law needs to be reformed. That's all I have to say.
And the thing that bothers me most about this is, if you put in the context of a normal TRO, as I mentioned right off the top, it's a no contact usually. That's far less onerous. Okay, we got to put that off for a week where you're going to contact the person anyway. I mean, in most cases, that TRO comes in to kind of cement the situation that's already in play. They don't have a lot of interest in one another, unless you have a harassment or a stalking kind of situation. So to extend the no contact, far less onerous than don't do what you do for a living, which is basically what this is saying. Don't do reporting because, we couldn't get to your case. That to me makes it even more outrageous.
Right. And it also muddies the waters in many cases, because you can be darn sure that in many cases the plaintiff, whoever got the restraining order in the first place, is telling everybody in many cases about what their perception of the other person is, and sort of hurting their reputation, perhaps even brigading or getting allies. Whereas the defendant in these cases, if this kind of order is in case, it can't even say, I can't even say the person's name, can't even say what's going on. And so it creates a social dynamic. And again, these are two separate people, two separate states. But if people are living in the same town, one's bad-mouthing the other one's not saying anything, people start to make conclusions. And unfortunately, that the social harm that causes to a reputation of defendant, completely legal as of right now, is very detrimental. And to sort of bar you from being able to say, I didn't do this, she's got the, or he's got the restraining order, but I didn't do anything they said. I think that causes more social harm in an attempt to protect potential plaintiffs. Again, the goals here are noble, but the enforcement, as many, many people can tell you, can be so wonky as to injure you for life, mentally and emotionally.
Yeah, I agree with the initial concept that you should have access to the courts to get these things resolved, and if you go in on your own and get a little help from the court, great, but not to abuse the process. not to use it as a weapon. It should be a shield of some sort if you truly have something you need protection from. But to use it as a machine gun, like here, I think that's ridiculous. So here's what I think. I'm not asking you to comment on this, but here's my take. Aidan Kearney shows up at one of the prior hearings without an attorney. They stiffen the order. They add this extra language. Now he's represented. Those representations, the notices of appearance, were filed a day or two before the proposed hearing. Oh, all of a sudden the hearing's off. I think any court, whether it was the presiding judge who was rubber stamping it and now is taking a deeper look, or the person who initially decided to represent to the court that it should be done, everybody is scrambling, saying, "Look, this is not going to be the pushover cakewalk that we thought it was, because we're getting pounded by some legitimate legal heavyweights here, and this little piddly case that we thought it was ain't so much anymore, and we probably aren't ready for what's coming on Wednesday." That's just my personal take. So
that's what I am hoping for. I'm hoping that the artillery starts firing in this kind of situation. Again, without passing judgment on whether he actually did the things, whether they're worthy of this. This strikes me as just completely overbroad. So I hope the First Amendment artillery is at least firing so hard that the court is running scared, and they amend this order to reduce it somewhat, because this is just ridiculous under the Constitution.
Yeah. That at the very least, address the real issues, whatever they may be, and take away this broad swath here. Now, Linda has not been on for reasons that are obvious. She's been involved in that case, but she can't stay away. I can't stay on or be a comment. I better put my glasses on here. So hold on a second. Linda says, "Hi everyone. I can't stay on to be on or comment." But miss talking over Michael. Yeah. Hope to see y'all again one day. That sounds ominous. By Linda. So
good luck, Linda. Good luck.
Yeah. So I think everybody is on the side of, I don't take sides on these kind of cases. To me, doing the right thing is not taking a side. You're either doing the right thing or you're not doing the right thing. And I don't think you have to be a genius to look at this order and say, yeah, that seems fair. That's all right. I'm okay with that. I don't get it. So,
no, I completely agree. On its face, you just go, how did the judge rubber stamp this? I just wonder that, and I think sometimes, given there's a huge volume of restraining orders in many state courts, I think may not have taken as close a look at it as possible. Again, I could be wrong. There could be valid reasons for it, but I don't see it on this. This just looks like Neer versus Minnesota all over again.
Yeah, and I think people would feel better about it if there had been a full-blown evidentiary hearing and somehow this became warranted. I can't imagine that scenario, but at least if it had been heard, that would make me feel a little bit better about it. But just this taking this machete to the First Amendment, that just chaps my hide.
Not to get off on a tangent, I don't mean to hijack, but
please tangent.
At a certain point, there becomes a question of habeas corpus with these kind of situations. Again, he's not in custody of the officials, but if he were to be accused of violating this and be taken into custody for this, there's a question of, does somebody raise habeas? Does somebody raise the fact that this is unconstitutional on its face, and does he have to violate to get that kind of justice? And he should not have to. They should not be in the order. There have been horrible instances in our history involving free speech where people were jailed based on what they might say in the future. Very famously in the Civil War, Abraham Lincoln, of all people, was arresting journalists in Maryland and throwing them in jail because some of them were being Maryland was a border state. Some of them were being what he thought was sympathetic to the South, and so he was tossing them in jail and without hearing. And it was a huge controversy at the time. It's one of those things you learn. Oh gosh. All presidents have some black marks against them, no matter how much you like them. Yeah.
And things are often a sign of the times, as it were, and the way society looks at something. But to me, I don't know how you get to this point, as a society. I just don't know how that happens, and I don't know if it's just a couple of wacko individuals, lazy people, could be lazy. Taking the path of least resistance because they think there's not going to be much resistance. So here's this person that comes in requesting this order. What's the big deal? Rubber stamp, and then all hell breaks loose because it ain't the right thing to do.
Yeah, the judge may not even know how big Turtle Boy has been and how big he's been to the free speech cause. He might have just thought, okay, just the next, again, without seeing the affidavit or hearing the testimony, we're all speculating, but that's the problem. We can't. And, even Mr. Kearney, this is chilling of free speech in a sense, because he is afraid to actually talk about his own case, which is supposed to be a matter of public record, which is designed to be a matter of public record so everyone can be protected. And many of these cases, especially restraining order related cases, you have the situation where the courts will, redact people's names and, try to hide identities of people from the public record. Because they'll claim, it's the sensitive nature of these kinds of hearings. But it's like it's a civil matter. Restraining orders are technically civil in most cases, not criminal. And it's one party against the other, and it's your word against them. It's not a situation where it's a child. It's not a situation where it's a person where, might be, mentally handicapped. Those kind of situations, protecting their identity is fine. But honest adults should be able to have their name on the record and have their cases discussed openly. And so when many of these restraining order cases hide the identities, and when I've appealed many restraining order cases, and here in Massachusetts, you can't use either party's name on an appeal in the public record. It's all either initials, or you can say John Doe or whatever, but you have to impound that information. But even if there's no criminal allegations in the case, or lurid details, I'll leave it to your audience to make up those details. But even if it's just a straight case of violence or just lack of violence, just threats, you're still not allowed to use that here in Massachusetts when you're appealing. And I'm sure it's similar in other states. And in my opinion, that is wrong.
I think it goes too far. And I would even apply that analysis in a rape allegation situation. I think if I'm going to be accused of that heinous act, the person accusing me should be revealed as well. Because my life could be ruined as a result of the allegation.
Right, and it could just be an allegation. And I know that many newspapers have taken upon themselves to do that in many rape allegation situations. They will not name the alleged victim, even if the alleged victim was an adult at the time. They won't name the victim, and to me, that's a discredit to our system. Again, both sides. We're not trying to have people target the alleged victim, but the alleged doer. Innocent until proven guilty, and stand up in court and make your statements. And so a lot of this stuff, I think, is going to need a lot of reform in the years going forward. It's going to be a confluence of constitutionality and just basic principles of common sense. We just can't have if you describe this to an alien coming down, he would say, well, that sounds kind of biased in favor of one party. Shouldn't you be trying for more neutral? That's what we go for. And I think we've gone too far in protecting alleged victims without protecting the accused, including in this case with Mr. Kearney.
Yep, I agree. And I did not know that the alien constitution so mirrored the common sense that we've been talking about.
Mr. Spock is a very fair man. Okay.
Well, logical. He's definitely logical. Hey, John, thank you so much. I appreciate your input on this. It's a discussion in a vacuum. Because we really don't know some of the extraneous, but I think there's certain things you can talk about, comment on, make sense about, in the case of this little blurb, it's irrelevant what the overall facts are. This order is unconstitutional on its face. And I hate to see it, but I appreciate you being here to help me be outraged.
You're welcome, Michael, anytime. And this is, I hope your partner there, I hope she reads them the Riot Act, or at least the First Amendment, so they know to at least amend this part of it. I don't know what the rest says. Again, this is part of the reform that I was talking about. Thank you for having me.
You bet. Why do I think she will? I'm pretty sure she will. Thanks, John. Bye-bye.
You're welcome. Have a good night. Bye now.
You too. All right. Linda is so shy. I'm afraid, she might just wallflower it in the courtroom. Anyway, we're going to move off of that. Originally, the plan tonight. A couple of things I want to do. There's a Kelsey Fitzsimmons update I want to give you, and then we're going to get into the former porn star accused decapitator in the Las Vegas / Henderson case. In Kelsey Fitzsimmons, remember we talked yesterday about the court docket suggesting, well, hey, We're going to listen to, we're not going to have a hearing. We're going to decide this on December 3rd. I had already prepared. I don't know if you were here on Monday with Ms. Demeanor. Remember John Cusack in that movie where he goes outside his wannabe would-be girlfriend's house and he's got the boombox on his head and he's blasting the song that I can't remember the name of. I'm sure you know it. I wanted to do that with the audio from the Kelsey Fitzsimmons hearing outside the appellate court, the SJC, and just so that if they haven't heard the audio yet, which is so critical to their decision making, I can help. Well, now it's not going to be December 3rd, or is it? Tom Bradle has put in a request to expedite the court's ruling. Remember the timing. The 10th is when they filed their motion or their petition. That was just Monday. 10 days were allowed for the Commonwealth District Attorney to respond, 20th. And then it was going to be kind of in the jello through Thanksgiving with a decision on the 3rd. So that at the very least puts Kelsey Fitzsimmons in jail on and through Thanksgiving. Clearly, that's bad. Every day is bad, but a holiday, the whole thing, you can figure that out. So he puts in a request to have it decided by the 21st, meaning the day after the petitioner's response by the state is made, the Commonwealth, sorry. They call that, if you look at the docket, the red and the blue. The briefs are color-coded, and they really are. So if they accelerate their decision to the day after all briefs are in, obviously a decision in the favor of Kelsey Fitzsimmons means she's out for both holidays and hopefully every day until trial, if there in fact is one in this case. Okay, so we'll see. The court hasn't responded to that. Not sure how they will, if they will, when they will, but I would imagine between now and the 20th, when the Commonwealth briefs are due, they will address it. But sometimes they address it by putting a line in the docket, and nothing really much more interesting than that. Okay, so let me give you the primer on what's happening in Las Vegas / Henderson. Have you ever been to Henderson? Henderson is like a weird little normal, quote, normal, I say, as we talk about a case that involves decapitation. Just outside of Las Vegas, it is southeast into the, you really kind of climb into it. Vegas is at about 2,000 feet, and I think it's at least 1,000 feet to Henderson. It's a little further up, but it's still high desert. But it's become a kind of bedroom community of Las Vegas. Cheaper to live there, more traditional tract homes, residences. And so it was in that location. You get the date on that. This was on June 7th in 2023. No, August 7th, 2023. Devyn Michaels, who's the former porn actress, is accused of killing Jonathan Willett, who is her baby daddy of 2 daughters. They have 2 daughters between them. And he was 46. She's currently 47. Apparently, they had a volatile relationship, not something we haven't heard many times. And on the night that he was killed, if you believe the prosecution, he was beaten with a stick of some sort and then ultimately decapitated, which amazes me, just the act of doing that, not just the heinous nature of it, but the physical aspect of cutting somebody's head off. So in the mix, we throw in her stepson, Devyn, I think is how you pronounce his name, Devyn Willett. She's married to him now. So the defendant, accused of chopping the head off of her baby daddy, is now married to one of the baby daddy's sons. Okay. But nothing unusual other than that. She originally pled to second-degree murder. We ran some of that with Bob Bianchi, who was guest hosting last night, the Riz. And it was just this bizarre hearing where she, through a rambling, crying, tear-filled argument about being innocent, that they retracted the plea. And then her attorney dropped out. That was in July. So then they come to trial. We're now at the end of the, it started late last week. So we're into the last part of the first full week. And so I thought this will be interesting because it's in West Coast time zone. So I thought, well, maybe it'll be interesting. Let's see if there's something, maybe we'll just dip into it live, and see what's going on. Well, earlier today, and I'm not sure it's still in this phase. I'm going to look right now, to be honest with you. There was Cellbrite, guys. Yeah, it was the local cops, but they used Cellbrite. And as soon as I heard that, I said, no, don't need that. That sounds like something that will bore us to tears and may not be all that interesting. So I'm looking now to see what we got that's currently live. Because Missy, if we wanted, we could pull this up, right? I'm looking now at the court TV feed, and it looks like one of the police interviews of the defendant, Devyn Michaels. Missy, is there any chance we can find that and pull that up? Because I have some video of one of the cops that was first on the scene, which has body cam and is very interesting and disturbing. But if we can get a sense of the defendant's, quote, testimony in the form of this police interview, maybe that'll be worth looking at. So what do you think? Let me take a look in the private chat. I don't see anything in the private chat. First time I've ever looked in the private chat, and I don't see anything. So in the absence of Missy popping that up, I think I will go ahead and show what is some of the testimony from a couple of days ago. That is when the one of the first responders showed up. See if I can find this for you. And what he had to say and what he saw that day. Unpleasant, but very important when it comes to the nature of this case. So let me see if I can get that rolling for you. If we can get into if Missy finds and we can get into the live courtroom, then we may listen to that as well. So make sure you guys,
Your Honor, permission
that you can hear this,
to
'cause
admit
I have
states
issues.
Exhibit 2 that I believe has been previously stipulated between the parties for its initial.
Absolutely, no objection.
Okay, states 2 will be amended?
Your Honor, permission to publish that exhibit?
Yes.
This is the body cam is what we're going to look at here. And Missy, feel free to interrupt if you snag that feed. Oh, Boise Great Dane, Henderson, your old stomping grounds, Green Valley Ranch. I'd love to hear some Henderson stories. Missy says she's on it.
Sir, are you able to see that in front of you at that computer screen?
Yes.
Okay. And what does that appear to be?
You sorry, what'd you say?
In front of you, what does that appear to be on the computer screen?
My body cam footage.
Okay, well let's get you to the house while we're waiting.
You're a drive. Are there already people at the?
So obviously they're taking in the gurney.
I mean a dog barking.
Okay. Do you recall the dogs being in the house at the time?
I don't recall if they were in the house.
Playing at 1:59.
Okay. So let's lock this down then.
Stopping it at 2 minutes, 19 seconds. Was that your voice there, sir?
Yes.
And what did you say in that video?
If it was missing head, let's lock it down.
Okay. And what does lock it down mean?
Meaning there's now a crime scene, so we kind of push everybody out and freeze that area to limit access to the house, essentially.
The initial response was not necessarily a response to a crime. Is that correct?
Not initially.
It was to see, essentially respond to what was being called into as someone that needed potential medical aid. Is that right?
Yes.
But one.
Okay, so just an update. Missy said they're running some police audio now, and it's brutal. So, and you wonder, don't clean your screen or your eyes. This is being distorted for a good reason because there happens to be a body in there without a
You
head.
saw this, you determined it appeared to be a crime scene, and you locked it down.
Yes.
Playing again at 2:19.
Lock this down. Let's FI them.
And I'm going to stop right there at 2 minutes, 32 seconds because I hear another term that we may not know. What does FI mean?
FI is a field interview. So essentially, we'll gather information, name, date of birth, things of that nature. it's a field interview of people involved.
Okay, and that was because you had seen, I believe we saw earlier in the video, 2 individuals that appeared to have lived in the residence that you wanted to do an interview of. Is that right?
Yes.
Playing again at 2:32.
Sarge, going from 2. Are you around?
Stopping the video at 2 minutes 50 seconds. I hear you on your radio. What are you doing at that point?
At this point, I'm just making sure, due to the nature of the call, making sure the supervisor is on his way.
And who was your supervisor that you were reaching out to?
Sergeant Shields.
And is that typical protocol to reach out to a supervisor in this
Yes.
type of situation?
Yes.
Okay. And when you went into the room, what were your initial observations of what you saw? Clearly, you saw a deceased person. Is that right?
Yes.
Anything unique about the body?
I think initially, obviously, that it was decapitated and there wasn't much blood initially that I figured it would be. And also there was like a strong, like chemical smell inside that room was the first initial things that were surprising to me.
Were you able to see what was used to cut off the head or kill the person?
No.
Playing at 2 minutes 50 seconds.
Copy. Hey, we're locking it down until we get here. No, 71. Hey, when you get here, can you grab a crime scene log?
And stopping at 3 minutes 8 seconds. What is a crime scene log?
Crime scene log is, once we determine it's a crime scene, it's pretty much a document to list out who enters or who exits that crime scene.
So in this video, you're essentially asking for one of those. Is that right?
Yes.
Okay, let me just tell folks, because I've seen some of the chat go by about, and did we miss the conversation about Turtle Boy? Yes, but I'll circle back before the top of the hour. So another 10 minutes, we'll watch this. I'll circle back. We'll go over the order that we talked to John Mateus about and kind of bring you back up to speed on that. So I appreciate those that are dropping in a little late.
Playing at 3:08. And I'm pausing at 3:11. Are those the 2 individuals that you saw in the home that appear to be residents?
Yes.
Were you able to, through your investigation, identify those 2 individuals?
Yes.
Okay. And was that Yoko Willette and Masao Yoshida?
Yes.
Playing at 3:11. And I'm stopping there at 3:24. We hear in the video that it appears to be only those 2 individuals as well as the deceased that was in the home at that time. Is that right?
Yes.
Playing
and
at
the yapping
3:24.
dogs.
Blood as you thought there would be. Reasonable assumption is maybe that body was decapitated somewhere else other than where you saw it laying in bed, correct?
I'm not sure if it was moved or what, just on my initial, it didn't seem.
Okay. You'd also testified that when you came into the residence, this smell hit you. I think your testimony was it was a strong smell, correct?
Yes.
Now, there were 2 other occupants at 849 when you arrived. It was Yoko and the couple that was
Yes.
standing there, correct?
Yes.
Was there ever an indication or a statement made to you by either one of them concerning the strong smell in the house?
No.
No. Thank you. No further questions. Good afternoon.
You solemnly swear or affirm the testimony about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Can you
Yes.
imagine those that were just the other 2 people in the house? Ugh.
My name is Forrest Shields, Forest, SHIELDS.
Good afternoon, sir.
Good afternoon.
How are you employed?
How am I employed with the
Yes,
city of Henderson? I'm a police sergeant.
How long have you worked as a police sergeant?
As a police sergeant, approximately 2 years.
Let's see if he gets, I think we get into more body cam in the next few minutes that we cover this. Interesting, you may recall from Massachusetts, there was an order from the court that no officers would be able to come into court in uniform. Not quite the same in Nevada. In fact, the guy that was just on looked like he just got off the SWAT truck. This guy looks a little less, military style, but he's full dress.
Thank you. Court's indulgence. State passes the witness, Your Honor.
Thank you. Sergeant Seals, you've been employed in law enforcement for 28 years.
Yes, sir.
Worked your way up.
Yes, sir.
You're an instructor.
Yes, sir.
A lot of experience.
Yes.
You testified that you've been in multiple crime scenes through these 28 years.
Yes.
Fair to say that a severed appendage, an arm or a leg is going to bleed, but a head, there's got to be a lot more blood going on there, correct? One would assume.
You would think so.
And you would testify that when you got there, having been on so many crime scenes, you go and you look in the bathroom because it just doesn't make sense. You're assuming this head wasn't, removed from the body here on the bed. It had to have been somewhere else. Fair to say?
No, I didn't say that. It seemed like because the shoulders were pulled to the edge of the bed, it appeared that it was done there. But I was looking to see, because the shoulders pulled over here. It didn't appear that it was done somewhere else.
But you said you went and looked in the bathroom, correct?
Yeah, to see if there was like cleanup, signs of struggle or something.
Blood?
Yeah, blood from washing your hands. Because I looked in the sink around the ring and didn't see anything that.
Based upon the blood markings on the bed, it was clear the body had been moved.
I can't say that.
Okay. Can't give an opinion one way or the other?
Well, the body was here. There was blood on the right side of the body. And like I said, directly under where the shoulders were, there was an area of blood like that. But
But you testified things just didn't seem right. And that's why you went and you looked in the bathroom, correct?
Yes.
And you'd agree with me. You talk about a bucket. That's just, you're speculating. You're hypothesizing, fair to say.
Absolutely.
And fair to say that you can't say. If something was wrong, so you went and you looked in the bathroom, correct? Based upon what you saw.
Based on what I saw, like I said, that is speculation, but it's like what made sense with the way that the blood was, the body was, lack of blood on the thing, the shoulders lined up with the side. And part of me going into the bathroom also is just before I turn things over to detectives, I want to make sure that I checked everything in case they have questions for me.
Fair enough. But again, you would have expected to have seen a lot more blood, correct? Had
Yes.
the head just been chopped off or sawed off or however removed there, correct?
If they were alive at the time, because typically when I have seen those injuries, if you're alive, your blood is pumping and it squirts. It's, I've seen a guy cut his neck and it squirts.
All over the place. If you ever had any cases
If they're
where
alive.
you ever had an experience though where a head's been cut off with a saw? Oh, people were dead.
Not that I know of.
Okay. So we don't know. Fair to say?
Fair to
But you
say.
went and looked in the bathroom, correct?
Yes, sir.
Thank you. No further questions.
All right. Gruesome stuff. You see where the defense is going here. They've been blaming stay with me, the son of the decedent, husband of the defendant. They've been trying to point fingers at, again, I think it's pronounced Devier, Willette, the son, stepson, now husband of the defendant. And so, and by the way, in case we haven't talked about this, the head was never found. They believed it was bagged and trashed somewhere, but never found. So you just think about the mechanics of it. This guy's saying, well, the body was slid to like the edge of the bed, almost imagine like a guillotine, where the head is just hanging off the edge of the bed. And then he brings up a great point that I hadn't really thought about. I heard all the testimony about very little blood, and that makes you wonder, it was, and the defense is suggesting, well, it happened elsewhere. Then they brought the headless body here. I'm sure that helps the defense theory that some other dude did it, and the other dude is the son. This sergeant is saying, well, if he was alive at the time they cut the head off, I would expect to see a lot more blood. And he got a little graphic about what he's seen in that context. But maybe that's it. Maybe the death came as a result of something else, something more innocuous, and they haven't really determined that cause. And then the head was chopped off, which would clearly limit the amount of blood. So it's an amazing case because of all of these weird familial connections. And it's just a gross case on balance. Why are people getting their heads cut off and arms cut off? What's with all the decapitations and the dismemberments? Because we've seen it in so many cases now. It just seems to me to be overkill, literally, figuratively. And we'll see what happens in this case as it continues. Like I said, they were doing a lot of cell phone testimony today. And then, of course, right now they go till what is effectively 7:30, 8 o'clock East Coast time. I thought we were going to get to dip into an interview with the defendant, but I guess it was really not worth the effort. So I don't understand that. This was 23, and they got video recordings in their precinct like it's 1930, and somebody's got they're cranking the film. It's brutal. Come on down. It's not that expensive. For $100, you can get an amazing Ring camera, a really good one. So anyway, so let's circle back because I know there were some folks who weren't here when we began the discussion, the Aidan Kearney situation, including Madeira Beach caregiver. Thank you so much. If I'm correct, the PLA is referenced by Turtle Boy using a nickname, Krusty. So since that word is used thousands of times in his audios, so now what? Remove the audio? Yeah, I don't. Well, in this particular case, and I'm going to bring the order up again. This is not a Krusty case, as far as I understand. Remember, it's not in that jurisdiction. It's in Atlantic City, New Jersey. So I don't believe that PLA is a universal identifier for somebody that may or may not be known as Krusty. I personally think there needs to be a Aidan Kearney dictionary of nicknames because I can't keep up. I can't keep up with all the nicknames that he comes up with. So let me bring this back up. This is the order, just to give folks a refresher for those who were not here right at the beginning. We had John Mateus, who was a First Amendment attorney. An action was filed, ex parte, single person plaintiff, complainant, because it is technically civil, a complainant, files this request for a temporary restraining order against Aidan Kearney. Okay, don't know what generated it, don't know anything about that. It's all sealed up. And again, further disclosure, Linda Kenney Baden is representing Aidan Kearney, as is Darren Gelber. We have not been in touch with any of this, so I'm just sussing it out from what I see and hear elsewhere. The person goes in, asks for a temporary restraining order, which in normal context means don't come near me, don't call me, don't contact me. It's a no contact type of order, and it's short term. It's short in duration because you're stripping somebody of their rights. Let's get in front of the court. A little due process would be nice. Let's make sure that before you deny somebody these rights, you've got the goods, okay? Well, before that even happens, there is an attempt to have the matter heard. Aidan Kearney shows up on his own, unrepresented, and the next thing he knows, he gets an updated temporary restraining order, which includes this number 6 other relief reference. Defendant to immediately remove any and look at this, to immediately remove any and all social media posts referring to PLA and family members, specifically any reference to PLA family members, any personal information or court-related issues or documents to be removed immediately. Failure to do so is a violation of this order and an arrestable offense. Any further post, okay, so now we're talking about things that have been done. Any further post referencing PLA, family, town, work, or anything else, that's not too broad, is it? Is a violation of the order and arrestable offense. Hearing officer rubber stamp, Rodney Cunningham, presiding judge rubber stamp. And so you get this mega order now in place. There's been no due process. There's been no hearing on the merits. There's been nothing except this edict from the court saying, not only are you being prior restrained from your First Amendment right to report on, talk about these things, but you have to cleanse everything you've already posted. That is such crap. It is so overreaching and so unconstitutional that it just makes me want to puke. So he's got help. We'll see what happens as this thing moves through the process. They have yet, as far as I know, gotten a hearing date. So this temporary restraining order, becomes indefinite until they get a date, and it will be very quickly extending the 10 days. You can see this was this updated order was November 5, so that's almost 10 days. But in fact, the original predated that, so we're past the 10 days from the original TRO. This is the now new and improved extended TRO, and we're going to be past that date by Saturday. Nothing happening tomorrow. If it does, obviously we'll bring it to you. But that's where we are with this latest extravaganza against Aidan Kearney. And for those that I don't give a rip, those that are so, Aidan can be a divisive guy. I get it. Fine. Don't like him, I don't care. This is the First Amendment case. For those who were anti-Karen Reed, and I filed the lawsuit against Massachusetts State Police, I was doing it for you too. And he's fighting for you too. Anybody that would like to speak their mind and do so legally under the First Amendment should have the right to do it. And when people like Aidan Kearney stand up, or I stand up, just say thank you and get the hell out of the way. All right? I don't want to hear any of that backlash. Well, he's a blah, 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 therefore. I don't care. I don't care what you think of the person who's defending his and your right to free speech. All right? So enough of that. I think I was just channeling a LKB rant there. Well, anyway, appreciate you joining tonight for two very bizarre different issues. One with the former porn star decapitator, allegedly, and with Aidan Kearney. I guess his rights have been cut off, and John Willette's head was cut off, if there's any sort of connection there. Tomorrow, don't forget, a very interesting interview with Haley Robson. She was one of the early and most vocal critics and survivors of the Jeffrey Epstein nightmare. And she's still in the thick of it as things continue to evolve. And it's an in-depth, it's not a quick hit on the mainstream media. It's an hour of discussion, and I think you ought to join. 6 o'clock, we'll do that as a premiere. So if you want to share, join and share comments with friends and other chatters, I think this is a great opportunity to do so. So that's it. As in the words of Kenney Baden, I hope to see you again at some point. It sounded kind of ominous. I have faith it'll happen sooner rather than later. So thank you again. Good to see everybody. Appreciate it. Have a great evening. And remember, this is Justice Served TV. Try to do the right.